Ladies and gentlemen, beautiful afternoon greetings from Malmö, Sweden, where the time is now 2 p.m. And welcome to this latest installment of the World Maritime University Alumni Webinar Series. My name is Max Mejia, Professor of Maritime Law and Policy here at the World Maritime University, and I have the pleasure of acting as your moderator for this webinar with the theme COVID-19 and Labor, Revisiting the Maritime Labor Convention 2006. When hundreds of thousands of seafarers find themselves in a worrying state of suspended animation due to a crew change crisis, we all find ourselves facing fundamental questions relating to the rights and welfare of seafarers. In searching for answers to these questions, many of us look to international law, particularly the Maritime Labor Convention of 2006, or MLC. MLC 2006 receives high praise for embedding the rights and welfare of seafarers within a single consolidated instrument. But is the convention able to protect the rights of seafarers in the time of Corona? How about issues related to seafarers' conditions of employment and occupational safety and health, or OSH? How is the pandemic affecting seafarers' mental health? These are some of the questions that this special webinar seeks to answer. To unravel these issues, we have assembled a distinguished panel of speakers for this afternoon's webinar. Our first panelist is none other than the president of the World Maritime University, Dr. Cleopatra Doumbia Henry. And it is important to note that before joining WMU, Dr. Doumbia Henry was director of the International Labor Standards Department of the International Labor Office in Geneva. And she personally shepherded the development and adoption of the Maritime Labor Convention 2006. Our next panelist is Dr. Laura Carballo Pinheiro, who is Nippon Foundation Chair, Professor of Maritime Labor Law and Policy here at WMU. Professor Carballo is also head of the Maritime Law and Policy specialization in our MSc program. Our third distinguished panelist is Dr. Maria Carrera Arce, who is senior researcher here at WMU. Dr. Carrera's research areas include maritime psychology, human behavior, well-being, and safety-related aspects. For a more complete profile of our panel speakers, please visit the WMU website at www.wmu.se. Now, a few words on the webinar format for this afternoon. During each of the expert panel presentations, we will be running a poll question which we will hope you, as the audience, will answer. After the panel presentations, we will have a Q&A session where our experts will field questions selected from the audience. So please send us your questions via the Q&A function. Finally, we will share with you the results of the polls just before we conclude the webinar. Our time for this webinar is limited, so let's get started. I now give the floor to our first speaker, Dr. Cleopatra Doumbia Henry.
Professor Mejia, thank you very much for opening up this webinar and for also giving the panel members who will be engaging with you today. Shipping is certainly vital for transport of goods and cargo, keeping countries supplied and fed, and provides the medical and other equipment that are needed to keep economies afloat. Seafarers are certainly no doubt among the world's workers who have encountered and continue to face the greatest challenges during the COVID-19 pandemic. They are today and will remain indispensable to world trade. The pandemic has had a significant impact on shipping schedules, with sailings being cancelled and port operations and logistic chains affected. The impact has included delays, rollovers, unpredictable, volatile, and reduced demand, and diminished service networks. 6 months have already passed since the World Health Organization declared COVID-19 disease a pandemic. Seafarers have found themselves for many months now on board ship well in excess of the required maximum period of 11 months provided for under the Maritime Labour Convention 2006 as amended. Over 300,000 of them have been unable for months now to disembark from their ships and to transfer and transit for purposes of repatriation, to get access to land, to shore-based facilities, and more importantly, access to medical care. This has also meant that a new set of crew members have not been able to join ship to replace them. The urgency to adopt measures to contain the pandemic cannot serve anymore to justify the suspension of basic human rights as are set out in the International Labour Organization's convention that I've referred to, the MLC 2006. As a result, basic human rights have been denied. Based on the latest information available, as of 28 September, many seafarers are still stranded on merchant ships, leading to dozens of labor violations that threaten seafarers' safety as well as that of the global supply chain. The MLC is called a Seafarers' Bill of Rights, and for good reason. It was designed and adopted by representatives of governments, ship owners, and seafarer organizations who were instrumental in its development and in ensuring that it can and would be adapted to meet future developments and challenges. The MLC came into force in August 2013 and consolidates into a single instrument and updates a body of 68 out of 72 maritime labor conventions and recommendations adopted by the ILO since 1920. As of the 6th of August 2020, it has been ratified by 97 member states of the ILO, representing 91% of the world gross tonnage of ships. We haven't seen much movement in recent times, I imagine, due to COVID-19. Unlike other ILO conventions, the MLC has a unique structure and has been mirrored to align itself with the structure of the IMO conventions. The core rights and obligations are enshrined in articles and regulations that are binding and can be amended through an express amendment procedure. However, the convention also provides for a code that consists of standards and guidelines. The standards are binding and they elaborate upon seafarers' employment and social rights, which are embodied in Article 5 of the MLC, the regulations and the standards, while the guidelines support the implementation of these standards. In accordance with the ILO Constitution, international labor standards that are ratified by ILO member states are binding on them. All ILO conventions are required to be transposed into national legislation. Often that doesn't happen. The monitoring and compliance with ratified conventions are monitored by a very sophisticated body, the ILO's Committee of Experts on the Application of Conventions and Recommendations, which was included in the ILO Constitution since the creation of that organization in 1919. The ILO turned 100 years last year. The committee, that's the Committee of Experts, is composed of 20 legal experts from all regions of the world and which meet once a year to evaluate and monitor compliance by ILO member states of conventions that they have ratified. The MLC is therefore a mandatory instrument which must be implemented in law and practice by states. Non-compliance can lead to submission of formal complaints submitted by ILO social partners as well as governments, workers and employers organizations. While the articles and the regulations of the MLC can only be amended by the International Labour Conference, the code can be amended through a simplified amendment procedure also by the International Labour Conference. A key feature of the MLC is the creation of a unique institution, the Special Tripartite Committee, that's composed of representatives of seafarers, ship owners, and governments, with a mandate to keep the working of the convention under continuous review. Since its adoption in 2006, the MLC has already been amended in 3 times, 2014, 2016, and 2018. I'm very proud to see a living instrument with the MLC. It is therefore a legal instrument that is designed to allow for rapid changes as needed, upholding core seafarers' rights. Already, 2 sets of amendments, those of 2014 and 2016, have already entered into force, and it is expected that the 3rd amendment will enter into force this year on the 26th of December. The STC has already met on 3 occasions, most recently in 2018, when it adopted important amendments to address the serious issue of piracy and armed robbery, as well as its impact on seafarers. On that occasion, the STC adopted provisions to allow the extension of the seafarers' employment agreements and related terms and benefits beyond their normal expiry date in support of seafarers who are held captive by pirates. And although COVID-19 pandemic bears no relation to piracy, it has resulted in seafarers being held captive by the virus, captive at sea. The STC issued an information note, and it was extraordinary to see this happen with the tripartite constituents, providing guidance on how to ensure legal compliance with the convention in the context of the pandemic. That's a tremendous achievement. The information note goes beyond addressing strictly the legal issues and also considers the importance of ensuring health and safety of seafarers, and in particular the extension of their seafarers' employment agreements with the seafarers' consent if circumstances mean that the seafarer cannot be repatriated or take annual leave. In such cases, the seafarer must agree freely and accept such an extension before signing any arrangement, on condition that all the benefits and the terms of employment remain the same. The action taken by the tripartite partners, governments, seafarers, and shipowner organizations offers an excellent example of international governance and cooperation. The advice of the STC has been included in the website of the IMO Key Port State Control Memorandum of Understanding, the European Union Commission, of course, in addition to the ILO. Indeed, the MLC provides a clear allocation of responsibilities when it comes to ensuring compliance and enforcement of seafarers' rights. Title V is essential to this end, highlighting flag state, port state, and labor supplying responsibilities. The MLC is based on the flag state principle in accordance with Article 94 of the UN Convention on the Law of the Sea, UNCLOS, and many of their requirements have been implemented and enforced by flag states. Flag states are under an obligation to inspect all ships. So do port states that enter into their territory. and ensure that they meet the requirements of the convention. Seagoing ships above 500 gross tons and above have also to be certified by port and flag states for control purposes. Ships are required to carry on board a maritime labor certificate and a declaration of maritime labor compliance. These documents attest to the ways in which flag states have implemented the MLC in national legislation and what steps the concerned ship owner has taken to comply with the provisions of the convention. Both flag state and port states have to establish a complaint procedure to enable seafarers and others concerned to denounce non-compliance with the requirements of the convention. Labor supplying countries also have responsibilities relating to recruitment and placement, operating in their territories, and providing social security, importantly, to all seafarers residing in their countries. They also have an obligation to ratify the ILO Convention number 185 as revised, the Seafarers Identity Documents Convention, in order to facilitate transit and transfer of seafarers. Flag states and port states, including labor supplying countries, are required under the MLC to ensure compliance with seafarers' rights and are expected to cooperate in this very challenging endeavor. Seafaring is a global profession, and in normal circumstances, it can only be carried out with the coordination of states, and more so in times of the pandemic, like COVID-19. Regrettably, countries have suspended the application of the MLC without acknowledging that seafarers are the unsung heroes of the pandemic. The good news is that during the pandemic, all the relevant United Nations agencies and maritime industry organizations came together and provided guidance to governments and industry to help address the issues that the pandemic gave rise to. However, more needs to be done. We still have too many seafarers out at sea waiting to be able to go home to meet their loved ones. It is good that on the 9th of July, the government of the United Kingdom hosted a virtual summit on crew change in order to address the impact of the pandemic. 13 countries signed a joint statement on facilitating crew changes and the designation of seafarers as key workers as set out by the IMO, the Secretary General in particular. Since then, 34 more countries have these designated seafarers as key workers. This designation is expected to ensure that all seafarers, including cruise ship workers, are exempt from travel restrictions and are able to travel to and from ships, which is key to enabling crew change. It will also ensure that commercial ships can continue to carry essential goods safely and without unnecessary interruptions. Global trade must continue. Governments also have also undertaken to accept as evidence of seafarers' status the ILO Seafarers Identity Documents. They have further agreed to implement the industry-approved protocols for ensuring safe ship crew changeover, review the national quarantine restrictions, and increase access to commercial flights to and from the principal countries of origin of seafarers. These developments have been welcomed and have offered an effective demonstration of how cooperation between governments, the United Nations agencies, can together produce important outcomes and thus help in addressing some of these daunting issues for the maritime industry. However, bottlenecks remain, as certain countries have tightened their crew change procedures. Until now, many airlines are still unwilling or unable to make flights available between shipping destinations and crew home countries. There has also been a lack of commitment by health and immigration authorities to facilitate travel by seafarers and issue visas. According to these industry actors themselves, despite global acceptance that seafarers are key workers, not all ports are honoring this commitment. An increasing number of countries have been prohibiting crew changes still, even though they welcome the essential cargoes that these ships bring to their shores. A fourth meeting of the Special Tripartite Committee, and I am really heartened to see that mechanism come into action again at the right time. What the committee did, in April of 2021, was to establish clear and robust mechanisms, ensuring that the rights of seafarers were respected, including their right to repatriation. Port states, flag states, labor supplying countries must implement and enforce these rights. 6 months after the global outbreak of COVID-19, these rights can no longer and should no longer be ignored by countries. In view of the issues raised by the pandemic, one proposal that I wish to put forward is that the STC consider to fill one gap relating to the right to repatriation, which could be included in Appendix A5.1 of the MLC through the introduction of a single additional item in the list contained in that appendix. My proposal is that the word repatriation be included in Appendix A5.1, one word. This can then be better enforced by ratifying countries, thereby improving living and working conditions for the world's seafarers on whom we depend so much and to whom we should be extremely grateful. Thank you.
Thank you, Dr. Dumbia Henry. I now invite our next panelist, Professor Laura Carballo Pinheiro.
Many thanks, Professor Maria. Thank you to you all that are out there listening to us. Special welcome to our graduates. I know that they have accompanying people with them, but a special welcome to our WNU graduates that are still interested in what we are doing here at the university. I am going to follow the lead set up by Dr. Dumbia Henry, and I am going to discuss some key issues of the Maritime Labor Convention that are related to the COVID-19 crisis. But I'm going to address them on a more general perspective relating to the content of the substantive part of the Maritime Labor Convention. The MLC 2006 has not been called a Seafarers' Bill of Rights without a reason. It is a Bill of Rights. It is a consolidated Maritime Labor Convention that provides us a holistic approach to the working and living conditions on board. So as Dr. Dumbia Henry was explaining before, these rights are spread out in quite a good number of pages within the Maritime Labor Convention, from Title I to Title IV. And there we have this holistic approach to the working and living conditions on board. Of course, I do not have time to approach all of them. They are basically discussing or going into the detail of employment and social rights on board. But I am going to focus on two titles, Title 2 and Title 4. Title 2 is entitled Conditions of Employment, and there I have selected 3 regulations: Seafarers Employment Agreement, Entitlement to Leave and Repatriation, and Title 4 dealing with health protection, accident prevention, etc. Well, I am going to discuss 4 regulations: medical care on board and ashore, ship owner's liability in the event of death or long-term disability, social security, and OSH programs, and occupational safety and health programs. Of course, this is going to be general, but I hope at least comprehensive in the approach, or capable of providing you an overview. Max, can you turn the slide? An overview about what is going on. The Maritime Labor Convention just set out minimum labor standards that have to be implemented into national legislations. As Dr. Domia Henry was first explaining, the obligations are addressing flat states, mainly border states, but also labor supplying countries. So when we think of the Maritime Labor Convention, we need to address the rights, the seafarers' rights included in there as implemented in national legislation. Because, of course, although the Maritime Labor Convention set up a minimum floor, states are expected to enhance those rights at the national level. On top of that, we need to remember that the core of the convention is an employment contract, and as such, it is also possible via the Seafarers Employment Agreement to set better standards for seafarers working on board the ship. The legal framework is provided by the Maritime Labor Convention as implemented in national legislation, but the basic rights of seafarers as negotiated between the ship owner and the seafarer have to be contained in the Seafarers Employment Agreement. Regulation 2.1 of the Maritime Labor Convention and the related standard and guideline discuss the particulars of the Seafaring Employment Agreement. In the midst of the COVID-19 crisis, I will call your attention to the fact that the Seafarers Employment Agreement has to be in writing, and before being signed by the seafarer and the ship owner, it has to be provided. I mean, the draft has to be provided to the seafarer for the seafarer to think carefully about the contents of the agreement and decide whether to sign or not, because this is a contract and it's required the free acceptance on the side of the seafarer. This is important to remember when we are listening to some flat states indicating that they are allowed for the extension of contracts. Well, the extension is related to the termination of the agreement. Sorry, here you have in letter G, this is a standard A2.1, and here we can find the particulars that the Seafarers Employment Agreement has to have in order to this contract to be a Seafarers Employment Agreement. It is pretty detailed. I have only selected the most important ones that I want to discuss, and one of the particulars is the termination of the agreement and the conditions thereof. So the contract has already to indicate whether it is indefinite or it is a short-term employment. That is unfortunately is the rule nowadays. Nevertheless, in order for a Seafarers Employment Agreement to be extended, it is not enough that a flat state so indicates, but the seafarer has to agree upon that. What happens if the seafarer decides not to extend the Seafarers Employment Agreement? Well, then he or she will be on board the ship without a Seafarers Employment Agreement, and that will trigger the enforcement mechanisms of the Maritime Labor Convention, meaning that either the flat state inspection or the border state control will be entitled to detain the ship, because one of the certified areas is actually to have a valid and ongoing Seafarers Employment Agreement on board. So we have to count on the will of the seafarer. The same applies when it comes to entitlement to leave. As you can see on letter F, and the Seafarers Employment Agreement have to indicate the annual leave. It has to be paid because it is a right, and holidays is a right to be enjoyed, meaning that it is rest hour time that has to be taken outside the ship. So that means that when it is established, if the contract is indefinite, entitlement to leave would entitle also repatriation of the seafarer. Annual leave is mandatory in most regulations because it is related to the health of the seafarer. It is about avoiding fatigue, and it means that we are protecting not only the health of the seafarer, but also safety on board. So entitlement to leave is also regulated within the Maritime Labour Convention, and it has to be provided as it is. It cannot be substituted by payment, but any type of payment. Among the particulars of the Seafarer Employment Agreements, we also find entitlement to repatriation. Repatriation, as we know, is a very important right to seafarers that is specifically addressed in Regulation 2.5. The details of repatriation has to be spelled out within the Seafarers Employment Agreement, but of course it's such an important right that we have a specific regulation that is mandatory for ship owners, but as you can see, as you can read on the regulation, actually the regulation is addressing the obligation of flat state to repatriate seafarers in those cases when the ship owner does not meet his or her obligation. And if the flat state fails to do so immediately, then the regulation is also clearly indicating that it is within the mandate of port states and labor supplying countries to repatriate seafarers. Actually, this regulation has been subject, the standard has been subject to the 2014 amendments to the Maritime Labour Convention because the system needed to be strengthened in light of what was going on with seafarers' abandonment. So we have a very complex system within the convention in order to cover the costs for repatriation. The main responsible for the costs of repatriation are, of course, seafarers. If they fail, then they are expected to have a financial security in place in order to cover the costs. If they have not paid for the financial security, but the seafarer has been recruited via a recruitment and placement agency, in those cases, labor supplying countries are expected to request the manning agencies to take financial security, some sort of insurance, to cover for those ship owners that fail to provide for the costs. Be that as it may, what the Convention clearly established it is that the obligation to repatriate, the final obligation, lies on the flat states. Flat states have to repatriate. Here in this crisis, what we are seeing is actually the states are the ones that are failing to repatriate because of the border restrictions. And that's also why seafarers should be designated as key workers, because while we understand that there is a reason to restrict access to the countries, the reason is to protect health, there should be exceptions, and one of those exceptions should be applicable to seafarers because of the essential work that they are undertaking. So we really need to think about that and to take actions, immediate action, because failing to repatriate seafarers is endangering not only their health but also their safety at sea. When it comes to the health of seafarers, we have a specific title, Title 4. Title 4 is very complete dealing with the medical coverage of seafarers. Again, remember that the convention is actually addressing states, although these states will finally have to require a specific action to ship owners. When it comes to health protection, states are expected to require the ship owners to provide medical care on board, but also ashore. And that means that here we are discussing the obligations that two countries have to take on, have to assume when they implement the Maritime Convention. Medical care on board, of course, lies under the mandate of flat states. Port states have to be on when it comes to medical care ashore. A different matter is who is going to pay for medical care on board and ashore. But it's important to remember that the provision has to be there and that medical care has to be provided either on board and ashore. And the one that has to make sure that that is happening is either the flat state or the port state. Ship owner liability refers to who is going to pay for that. Anyway, that is about medical care that has to be provided during the time of the Seafarers Employment Agreement. So the coverage is, the medical coverage is linked to the fact that we have an ongoing Seafarers Employment Agreement, because of course we are discussing the time when the seafarer is on board or when the seafarer acquires a disease or injury or goes through an accident that is occupational, related to the work on board. And the ship owner is the one responsible for that coverage. If we are facing death or long-term disability, so the ship owners also has liability to provide for some compensation after the employment. The convention limits that coverage because the convention also indicates that countries, and in this case the convention is clearly allocating the main responsibility to labor supplying countries to provide social security protection. It is important to note that the convention allocates the main responsibility to labor supplying countries, because we are talking of the country of the residence of the seafarer. That country is the more stable, the main stable connection in the life of the seafarer. Otherwise, seafarers are moving from one flat state to other flat state, and that's the country where the seafarer will be able to get benefits. And in these times of the pandemic, the issue is incredibly important, because during the time that the seafarer is at home, usually it is not covered by a seafarers employment agreement, so should be able to get at least unemployment benefits from the social security protection, as well as medical care benefit from his or her country of residence. The convention is really comprehensive when it comes to addressing the occupational safety and health of seafarers. I invite you to read Regulation 4.3 and the related standards and guidelines, because there we have a comprehensive overview about the meaning of occupational safety and health. What is the meaning of that, and how flat state, maybe flat states and port states should be providing those providing that matters to seafarers. Of course, the OSH matters refers basically to the right to live, work, and train on a healthy, safe, and hygienic environment. And in order to do that, the main responsibility is allocated to flat states that have to provide laws, regulations, and guidelines that address OSH matters on board. And what type of laws, regulations, and guidelines? Well, OSH is really a comprehensive concept that addresses in a holistic manner the safety and health on board. Just to mention the key core of OSH, they have to cover the technical prescriptions, for example, the ergonomics on board in order to prevent accidents, risk assessment and management. So here the convention is making a link with the ISM code, occupational medicine, for example, in order to prevent fatigue. And it also covers psychological and psychosocial factors at work, the dynamics between employer and employee and co-employees, trying to avoid, for example, conflicts on board. And about this, Dr. Carrera will explain more later on. The flat state is expected to provide a comprehensive set of laws and regulations and guidelines about OSH matters, but actually the one that finally will be implemented, those programs on board, is the ship owner. So addressing all these factors, items that I have just listed, what it means that it has to provide a comprehensive set of programs. That will not go under the radar of the flat state because we have a specific document, the Declaration of Maritime Labor Compliance, that have a part 2. Part 1 details the national provisions that have implemented the Maritime Labor Convention, but the part 2 has to be filled in by the ship owner, and one of the items that the ship owner will have to detail in that part 2 is these OSH programs that had to be set up on board and discussing OSH matters. And that document has to be sent to the flat state administration in order to make sure that the ship owners is actually in compliance with this obligation of the convention. When addressing OSH programs, and this is especially important in COVID-19 times, we have to remember that port states have also to engage with occupational safety and health, because they have to provide access to shore-based facilities. It goes without saying that this is a key element in the health of seafarers. Seafarers, as a colleague of us likes to say, seafarers are not fish, are humans, and they have to get access to shore for the well-being. This is a key element. So despite being so restricted in allowing people to get access to the port, these states need to remember that it is also essential for their health. So the convention, in this case, in regulation 4.4, establishes that it's mandatory for port states to provide access to shore-based facilities, to establish shore-based facilities, and those shore-based facilities should be run by welfare boards that specifically we designed programs thinking of the well-being of seafarers. So hoping that I have not exceeded my time, I finish.
Thank you, Dr. Caballo. I would now like to invite Dr. Maria Carrera Arce, our next panelist, please.
Okay, so first of all, I'm very glad to be here, and thank you everyone who is joining us today. Big hello to all of you virtually. So thank you, Professor Mejia, for your kind introduction, and thank you to our President Cleopatra and Professor Caballo for providing the general legal framework and responsibilities to some of the aspects I'm going to focus on right now. So I'm going to highlight the psychological health and safety aspects on board ships, which is the work environment for seafarers, and these aspects are being highly impacted by COVID-19 pandemic. Okay. So first of all, I like to start by providing a description of what health is. According to the World Health Organization, health is a state of complete physical, mental, and social well-being, but not merely the absence of disease or infirmity. This definition has two main implications for mental health. First of all, it implicates that mental health is an integral part of health, so there is not a health without mental health. Recently, a student of our university has conducted a study, and she explored the well-being of seafarers, and she specifically, among other aspects, asked them about this concept, about what they thought, and mainly all of them consider that mental health is a vital aspect of health. So this is indicating, among other things, that this is not as taboo as it used to be. The other implication is that mental health, with this definition of health, mental health is moving away from the traditional perspective that basically said that, okay, mental health is if I have a disorder, if I don't have a disorder, if I am sick, if I'm not sick. This is a more dimensional approach. In fact, okay, let's see. Probably it's not moving. Oh, no. Okay. As described by the World Health Organization, mental health is a state of well-being in which an individual realizes her own abilities, can cope with the normal stresses of life, can work productively, and is able to make a contribution to her community. So main aspects here, along with moving away from that traditional concept of mental illness, we are focusing here on promoting positive feelings, on promoting positive functioning, because these two aspects are very important when it comes to mental health, well-being, but also to job performance and as a consequence to safety. So the Maritime Labour Convention mainly addresses mental health aspects on Title 4, on health protection, medical care, welfare, and social security protection. But of course, if other titles content are infringed, of course, this will also affect our seafarers' mental health. For example, as part of Title 3 on providing recreational facilities, providing good accommodation. If the accommodation is not good or not well designed, if there are not recreational activities, facilities, sorry, this will have an impact on psychological health, job performance, and as a consequence, safety. The Maritime Labour Convention, along with identifying the importance of providing medical care both on board ship and offshore, also highlights that it's important to put into place measures of a preventive character, such as health promotion and health education programs. Mental health education programs are not specifically described, but as previously mentioned, mental health is part of general health of an individual. Along with this, the Maritime Labour Convention also says the importance of promoting occupational health and safety policies and programs, as previously described by Professor Carballo. And the Maritime Labour Convention, among other aspects, consider to manage effectively aspects such as physical and mental effects of fatigue, design aspects which affect, of course, mental health on individuals, mental occupational health effects, and harassment, bullying, among others. The Maritime Labour Convention also considers that in order to conduct investigations, psychological problems created by the shipboard environment must be addressed. Also, physical stress on board ship, and in particular as a consequence of increased workload. Increased workload, along with other aspects such as lack of sleep, are being clearly identified in studies as major contributors to fatigue, which is a major contribution to well-being of seafarers. And finally, as also described by Professor Carballo, it's very important to provide seafarers access to shore-based welfare facilities. In many cases, they are having probably some access to shore, but in some cases they can go beyond the gangway, so of course they don't have access to these welfare facilities, which is their rights. So we can say that in general, several psychological, social, social and also biological factors determine the mental health of an individual at any point of time. But the World Health Organization also, let's say, recognizes big stressors, okay, that are associated with poor mental health. Among these stressors, they mention infringement of human rights and rapid social change. Let's say that these two aspects are being heavily affected among our seafarers. In fact, we can define the COVID-19 like a rapid social change. Let's say that the COVID-19 is a qualitative transformation within the society that is provoking big change and altering our societal state, okay? So among other aspects that are highly impacted by COVID-19, we have long contracts for those who are on board. Also, we can't forget those who are unemployed at home. Another important aspect is that the repatriation is being delayed. Previously mentioned the importance of lack of shore leave or limited access to welfare facilities in port. This is clearly identified in research as a major contributor to well-being of seafarers. Of course, we have more fatigue, more work stressful environment, and this will affect the safety pretty much. And we also have more isolation, not only on board, also when some of our seafarers go back home, because in some countries they are being seen as carriers of the virus. Okay, so all these aspects must be taken into consideration. So all this, let's say, is leading to a great focus, to a great interest on mental health of seafarers. In fact, charities, maritime charities, also ship management companies are identifying that our seafarers are using helplines more frequently. In fact, there is some evidence that the number of suicides is increasing, especially on board passenger vessels. The Australian Maritime Safety Agency manages data that imply that the number of person on board incidents is increasing as well. AMSA has also identified that the number of complaints, Maritime Labour Convention complaints, is increasing pretty much in a 40%. For example, the mission to Seafarer, who publishes how well our seafarers are through an index of happiness. They report every quarter in the year. This is indicating that they are feeling less happy, their well-being is pretty much affected, and pretty much in relation to the lack of shore leave, among other aspects. So all this is indicating that, of course, we must be aware of the importance of these aspects. We have to promote how to deal with these aspects. There is a need of a clear management, coordinated management of well-being and mental health of seafarers, but we have to avoid stigmatization, because this is not indicating that our seafarers are mentally ill at all, but the opposite, they are showing great resilience. So we have to be also very cautious about this. So regarding specifically occupational health and safety programs, an occupational health and safety program is, let's say, a plan designed to prevent incidents, to prevent occupational diseases, disorders, problems. So the Maritime Labour Convention clearly indicates the importance of these programs, and consider that we have to approach these programs from a preventive perspective and promote health education, health training. For example, the STCW doesn't have a specific training about raising awareness of mental health and well-being, other than emergency preparedness or first aid. So this could be something to take into consideration. These programs should have a holistic approach and include physical, mental, and social aspects. These programs should be oriented to individual aspects, but also interpersonal aspects, community aspects, and we can't forget families of seafarers, organizational aspects, for example, how organizations deal with fatigue, which pretty much affects well-being. These programs should also include all those factors related to design, psychosocial, and work-related that affect seafarers' well-being. The use of technology also has a role to play here, and there are some applications that seafarers are using, but there is some kind of coordination, and in some cases they use them, not in all of them. So this implies for a coordinated strategies that consider also the effects of COVID-19, not only in the short time, but also in the medium and long term, because the real effects of the pandemic will come later, not right now. Okay, so this is it. Thank you so much.
Thank you very much, Dr. Arce.
Thank you.
Dr. Carrera Arce. Now we have come to the end of the panel presentations, and would like to open the floor now for some questions and answer. So we start the Q&A session. We also have only about 10 minutes left of our time, so I think I will field perhaps one question each to our panelists before we then share the results of the polls. Perhaps I could refer this first question to our president, Dr. Cleopatra Doumbia Henry. We have a question from the audience that goes as follows. As far as I know, the MLC is not an IMO convention, and de facto it is not part of the IMSAS audit. Such an important instrument is not part of the monitoring system. Do you think it could be possible to establish a joint audit system in parallel with the current IMSAS structure?
Thank you, Professor Mejia. With respect to this question, in fact, the ILO does have it is probably one of the UN organizations that have probably the most sophisticated monitoring mechanism and supervision of the implementation of conventions. I don't think there is another one, especially with the comprehensive nature of the number of instruments the ILO has adopted to date, almost 200. And so the ILO has in place since 1919, as I think I said in the beginning, a supervisory body that monitors countries' compliance of all ratified conventions on a regular basis. Certain conventions on a more regular basis than others. Therefore, the Maritime Labour Convention falls within the scope of monitoring by the ILO supervisory bodies, and that is the most, of course, important one that on a regular basis meets every year is the ILO Committee of Experts on the Application of Conventions and Recommendations. So that monitoring system, of course, countries have to submit reports on a regular basis, so according to the timeline set, for review by the ILO Committee of Experts on how countries are implementing their obligations under the convention. But what's interesting about that supervisory mechanism is that employers and workers organizations, particularly workers organizations, use this very effectively. Employers and workers organizations can file comments, can submit complaints, they can also provide inputs into the work of the ILO Committee of Experts outside of being able to file a complaint under Article 26 of the ILO Constitution or a representation under the convention as well, under the ILO Constitution as well. On that is Article, that's an Article 24 provision, and therefore they can bring the issues that they have to the supervisory bodies of the ILO, and of course there are other mechanisms as well, but particularly this supervisory body of the ILO is very effective. Of course, a lot depends on the, and I have seen very few in my years, few complaints being brought with respect to maritime compliance with maritime labor conventions. It happens more often with the other instruments. It is my hope that the seafarers organizations are much more effective in its use where they see abuse or where they have concerns. So there is a system that's in place that's very effective if it is well used, and if, of course, seafarers are aware, and their organizations, more importantly, the organizations of seafarers. An individual cannot bring the contract, a claim forward, but the organizations or the countries can do so.
Thank you, Madam President. I'd like to refer this next question to Professor Carballo. And the question goes as follows. May I ask whether repatriation includes the cost of quarantine expenses during the pandemic? Because some companies don't seem to pay those expenses when signing on or off.
Thank you so much for the question. It's a very interesting one, and it's a very good one. The problem is that the Maritime Labor Convention didn't count on a pandemic when it was drafted. Maybe now, when we have the special tripartite committee meeting, they can discuss issues as this one. Actually, regulation standard 82.5.1 requires flat states to specify the precise entitlements to be accorded by ship owners for repatriation. So we need to have a list of those expenses, and of course, quarantine cost is not taken into account. However, the convention indicates the item of expense to be covered and other arrangements to be made by ship owners. So reasonable costs that have to be undertaken, because in line with the repatriation could be interpreted in national legislation as being under the obligation of the ship owners. But of course, since the Maritime Labor Convention does not specifically mention that issue, well, it is a matter for discussion. Unfortunately, it's a matter for discussion and to be decided between the ship owner and the seafarer, and ultimately by the courts of the relevant jurisdiction.
Thank you, Professor Carballo. This next question I would like to refer to Dr. Carrera. Does the World Maritime University have an ongoing or upcoming study on mental health of international seafarers?
Mm-hmm. Okay, thank you so much for your question. Probably more studies on this to come, but what I can say for now is that many of our students are pretty interested in this specific topic. For example, our current students who have or are about to finish their studies this year have conducted studies, have conducted research on this specific topic. One of them has explored the mental health and well-being of seafarers, specifically trying to explore and promote the role of maritime education and training. And another student has also conducted a study about this specific topic of mental health, well-being of seafarers. Have analyzed major contributors to this, identifying, for example, lack of sleep and stress of workload as major contributors to fatigue, and fatigue contributing to mental health. But of course, other factors have been identified, such as, for example, onshore lack of onshore leave, or lack of recreational facilities, weak interaction with colleagues on board. Also, internet connection is an aspect that is becoming quite relevant when it comes to define well-being of our seafarers. So I can say that many of our students are particularly interested in these topics. You know, they come from countries all around the world, from different maritime organizations, and it's pretty good to see that this interest. Yeah.
Thank you, Dr. Carrera. We have time for only one more question, I'm afraid, and we'll take one from a very dear friend of the World Maritime University, Professor Edgar Gold, sending us this question from Brisbane, Australia. And I will refer to Dr. Dumbia Henry. The main difficulty is that most flag states are either not willing, able, or capable of doing what they are required to do under the Maritime Labour Convention. Is that not a serious weakness?
Well, indeed, you have flag states and you have port states, and the MLC gives responsibilities to both. In fact, I think the major concern is probably the weakness of flag states. Flag states today are developing countries to a large extent. 90% of, I would say, shipping, they're flagged in developing countries. And I'm coming from one of those. So what I have seen in my years is because the flag state is the ship hardly ever really goes to that particular flag state, and if it does, it's not that often, or we have weak, in other words, we have governments, developing countries that are flag states, are weak countries, very often are weak countries. I can identify them. While they are flagged in those countries, they are actually operated elsewhere. So this is a big, I would say, one of the big gaps. Of course, as an academic, I can say that is a big gap. It does not make, as a result, most of, in terms of inspection and enforcement, you see it happens with respect to port states. Port state control, including the Paris MOU probably, is the most effective port state control organization that I'm aware of. Of course, you also have the Tokyo MOU. They are also quite active. But port state control MOU, the Paris MOU is probably one of the most effective ones. And that is where you see more the effective enforcement of the Maritime Labour Convention as one of the conventions, of course, among others, that is all the IMO conventions that are more effectively monitored. Unfortunately, the weakness of our flag states in compliance, ensuring full compliance, or particularly considering that the seafarers are actually coming from many of the developing countries, but not necessarily those that are flag states.
Thank you, Dr. Dumbia Henry. I'm afraid we're out of time as far as the Q&A is concerned. We do have quite a few more questions, but from the audience, but please rest assured that we will revert to you with some answers to them after the webinar through email. So for now, I'd like to thank everyone who sent us their questions, very interesting questions indeed, and thank the panelists for giving us some excellent answers to them. And now I would like to share the results of the polls, which you as participants have so very kindly participated. And sorry, let me see. I think I might have to refresh the file because this has just been recently updated with the results. Okay, here we are. So as you can see, poll number 1, is your country facilitating crew changes? We can see that 64% have answered yes, 9% or 3 out of 33 answered no, and 9 out of 33, meaning 27% were not aware or were not sure of the answer. Poll number 2, has your country set up an administrative structure to comply with the obligations placed upon it by the Maritime Labor Convention 2006 as a flag state, port state, and or labor supplying country? Yes, we have 19 of 40, that's 48%. The no's, 3 out of 40, that's 8%. And I don't know, 18 of 40, that's 45%. And our third poll question, number 3, do you find that the MLC 2006 is an effective instrument to address mental health and well-being of seafarers? We had 23 of 39 answering yes, that's 59%, 10 out of 39 saying no, that's 26%, and 6 of 39, 15% saying I don't know. So again, thank you very much for participating in the webinar, fielding some excellent questions, and also participating in the polls. I would like to thank my colleagues here, those particularly who were instrumental in organizing this webinar, Pete and Charlotte. I would like to thank our excellent panel of distinguished experts, Dr. Cleopatra Dumbia Henry, Professor Laura Carballo Pinheiro, and Dr.